Good afternoon. I thank the Bingham Center for the Rule of Law and the journal Theory and Practice of Legislation for the invitation to speak about global legislatives responsive to coronavirus, Switzerland. Let me start with some thoughts about the Swiss constitution and some constitutional aspects when we talk about emergency legislation. In the time of crisis, important decisions must be taken quickly. So typically, such powers shift to the executive branch. Switzerland is no exception. According to Article 185, paragraph 3 of the Swiss Constitution, the Swiss Federal Council may issue ordinances and administrative acts in order to counter existing or imminent threats of serious disruption to public order or internal or external security. It is undisputed that the current pandemic qualifies as an imminent threat of serious disruption to public order or internal or external security under this article. Less certain is the question whether the Constitution not only allows police measures, but also financial ones aiming to address the social and economic hardship that follows from the lockdown. The Federal Council invoked this provision in order to support the Swiss bank UBS in the year 2008, but many doubted the constitutionality of this help. However, newer doctrine tends to include social and economic emergencies and measures addressing them, so we have still a dispute or a discussion of whether the current pandemic qualifies, but I would say the majority of Swiss scholars and also constitutional practice supports that in the current situation, 185 of the Swiss Constitution was invoked. What is the role of the parliament? You see a picture of the Swiss parliament. The federal parliament was in session during the height of the crisis. Still on March 15, 2020, the offices of both chambers decided to abort the session. Although one chamber at the beginning of the same week explicitly rejected such a motion. The offices also suspended all committee meetings. Decisions of the offices attracted widespread criticism. It is doubtful that these decisions were legally correct. The offices of the chambers have mainly an administrative function, and their members do not enjoy superior authority compared to other members of parliament. But it shows that, at least from the institutional standpoint, the parliament was not ready for the crisis. And certainly, if one was to think about what we could improve for the future, we would have to have some provision addressing exactly that situation. But what is the role of parliament? Because why do we need parliament in the times of crisis? I think the parliament has an important role, even in a time of crisis. Approval, oversight, emergency legislation in its own right are the rights and duties of parliament. The legitimacy of the executive branch goes only as far as parliament is not able to react to the crisis. Important decisions also in the times of crisis must be still taken by parliament. So the delimitation of powers between the executive and the legislative branch depends on the need of imminent action. This idea was not there in the very beginning of the crisis, but this has gained acceptance that indeed we need also parliament in the time of crisis. So if we need parliament, who will decide that actually parliaments can convene? It's interesting, on the federal level, the competence of parliament to decide on its sessions was never put in question. However, on the cantonal, on the state level in Switzerland, the exact same question was indeed debated. The parliament of the canton of Zurich, the Kantonsrat, was denied an exceptional permit by the local health department. The Parliament did not accept it. Based on expert opinion, the office of the Kantonsrat protested, and the cantonal executive branch quickly confirmed that the Kantonsrat itself was in charge to allow for an exception, thereby following the argument that the separation of powers implied that each power decided by itself and under what form it shall convene. In Zurich, the sessions of Parliament was particularly relevant as the cantonal constitution required immediate approval of any emergency ordinances enacted by Parliament. So, at least in Switzerland, it became accepted that the question whether Parliament shall convene is a question that must be decided by the Parliament itself. In what form? Do we prefer a limited composition or video conferences for the Parliament? Quickly in the height of the crisis came up the question whether parliaments may convene electronically. However, in the respective acts concerning the functioning of Parliament, there was no basis to meet by video conferences and such, and at least not for a plenary session. So what are the legal problems of convening in the form you're seeing here? We see here a large area where people should be able to convene without too much risk. The problem was that in Switzerland, as in many countries, particularly vulnerable persons should stay at home. And really staying at home means also not going to Parliament if you are a member of Parliament. But still, participation in the sessions is mandatory, and you probably see the tensions or the potential conflict that actually, in one hand, vulnerable people should not attend Parliament, but on the other hand, if they're a member of Parliament, they should go. And this is not only a problem of these members not being able to execute their rights, but it's also a problem if you consider the representation of Parliament. It means that the most vulnerable people that are most concerned by the pandemic will not be able to participate in the plenary sessions of Parliament if they follow the order to stay at home. Technically, a lower participation is not a problem provided we have a quota or we reach the quota. But of course, if you have a little bit different composition of Parliament, this changes the composition of Parliament based on a criteria that is considered highly problematic. Under the Equal Protection Clause, as in many countries, you should not discriminate against old people and you should not discriminate against people that are ill. So we think that in Switzerland we had some sessions in this setting. These sessions were valid, but I think there's some agreement that these sessions were constitutionally encumbered by the way of composition. And it's certainly one desiderata of a revision of the Acts of Parliament that in the next crisis, we hope not to live through, we would have some rules whether electronic meetings are permissible or not. These were my very brief thoughts. Obviously there's much more in the paper, but I'm looking forward to the discussion. Thank you very much.